Hi there. Once again, I am going live to Twitch, which I may remove if it's not pleasing to me in post recording. And I will be going recorded to Facebook, my Facebook account seen here, Dominus Rex, Dominus space Rex, or the Human Douchebag, at www.facebook.com/dominus.rex.ca / as the URL. So I want to approach the serious legal concerns that apply to me and to this society in a more general sense via this platform, firstly, so that I can organize a lot of the information and make it available for people's assessment in an objective way. Because whether you happen to work in the justice system and are a judge, a justice, a police officer, a lawyer, or something like that, or you're a member of the general public, determines a lot of your knowledge and your predispositions toward certain opinions within that context. And I feel that anybody could benefit and learn. And there are a couple things that I want to touch on before I review some of the actual case files via the CanLII legal system. And we also review some of the audio transcripts pertaining to the judge's verdict in my case. And I just wanted to, in my circumstance, draw some attention to the BC Civil Liberties Association and their social media offerings, because anybody who is concerned about their human and national rights within Canada, trying to relate documents, legislation such as the Universal Declaration of Human Rights on behalf of the United Nations, the Charter of Rights and Freedoms, and the BC Human Rights Code, and things of that nature, with the reality of the processing of various cases through the justice system, and the BC Civil Liberties' role in drawing attention and communication amongst citizens, favoring the advocacy of such rights. I just wanted to review some of the content that is present so that we can assess the ultimate capabilities of organizations like the BC Civil Liberties Association to effectively administer the responsibilities of their role, of their intended purpose. So at the top of their timeline, posted August 11th, 2 days ago, we have this unfortunate Soleiman Farik, he who died, and I just wanted to briefly consider this man's unfortunate death. And we'll just, I mean, I know this has nothing to do with me directly, but I just thought that we might look over what the BCCLA is offering us in such capacity. So, we'll just quickly read this over.
Ontario's chief pathologist determines what killed Soleiman Fakiri, 5 years after he died behind bars. Soleiman Fakiri, or Soli as his family knew him, was once a straight-A student and captain of his high school football team. But he was diagnosed with schizophrenia at 18 after a car accident. The province's chief forensic pathologist released a report Tuesday determining the cause of Fakiri's 2016 death in an Ontario jail. Submitted by Yusuf Fakiri. 5 years after Soleiman Fakiri died on the floor of an Ontario jail, shackled, pepper-sprayed and face down with his head covered, the province's chief forensic pathologist has determined just what killed him. It's the answer to a question his family has been asking for years, only to be told again and again there was no way of knowing how the 30-year-old with schizophrenia died behind bars as he awaited transfer to a medical facility. Until now. Fakiri's official cause of death, as found by Dr. Michael Polanen, prone position restraint and musculocutaneous injuries sustained during struggle, exertion and pepper spray exposure, in a person with an enlarged heart and worsening schizophrenia. In other words, Fakiri's death was the result of being held face down on his stomach and the injuries he suffered while being physically restrained and repeatedly struck by a group of at least 6 guards at the Central East Correctional Center in Lindsay, on.
So this is what I've noticed in reviewing a number of the other news stories of similar instances where people have died in police custody. And myself, having been restrained with a spit bag placed over my head, restricting my breathing, and my hands handcuffed behind my lower back, or on my waist behind me, it's a very, very potentially dangerous method that they use to restrain people in such respect. And even at my level of fairly good physical health and a steady good health and a good fitness and workout and dietary routine, I still felt panic when I was placed in that situation by arresting officers. And in the case of them already being in custody, in the case of a victim like this already being in custody, there's really no excuses. That, like, I think once somebody is in a detention center, is in a jail, is already detained, there should really never be an opportunity for things to go wrong. It should be under control at that point. And it's just so sad that these people are basically subjected to one of the most terrible fates imaginable, because it is different to suffer when other people are subjecting you to their physical actions. I mean, like, you're either sustaining injury or death at the hands of human beings with intention, with consciousness, and there's a very significant aspect to that in comparison to suffering fate as the result of a random occurrence or an accident or something like that. If there's no individuals to actually clearly hold responsible for the death or for the injury or for the treatment, if there's no specific it resonates much differently in the mind of a person. When accidents occur and it's a random occurrence, that's one thing. But when it's human beings inflicting this kind of thing on other people, let alone human beings that are placed into authoritative and authoritative situations and control, and entrusted on behalf of society and the government in order to execute their responsibilities over us in a physical sense, which is yet another layer of concern. And I just think that needs to be acknowledged. When people are victimized, number one, when people are victimized in crime and have to suffer through the hands of other people, that's one thing. But it's a whole another level up when those same individuals are supposed to be the ones that are the trustworthy, good members of society, according to the establishment. It's that much more horrific, in my opinion, and psychologically traumatic as well.
ONT, in 2016. Multiple musculocutaneous injuries were present due to blunt trauma caused by some combination of correctional officers striking Soliman Fakiri, or his body hitting the ground or stationary objects during a violent struggle with the correctional officers, Polonen said in a peer-reviewed forensic pathology review report dated August 5. None of the injuries were individually fatal, Polonen said in the report. But, in combination, the injuries were a significant contributing factor in death. Case referred back to provincial police, lawyers say. It's a grim conclusion, but one his family can find some measure of peace in after years of anguish over a truth they've believed in all along. At the end of the day, is there relief? Yes and no. Soli is gone, he's not coming back, and a part of my family died that day.
And this is the important thing to consider, is that there is no reconciliation. For people who are imprisoned for years or decades of their lives wrongfully, you can pay them money, but realistically, if I lost a decade of my life because somebody maliciously prosecuted me, or just made an error, or a judge failed to execute the responsibilities of their office entirely correctly, or lawyers refused to step up and actually put in the effort necessary in order to achieve a more accurate sense of justice, I don't think there's any amount of money that you could compensate me that would make up for the conditions, for the time lost, for all of the detriment that it caused. There's really no reconciliation. Money is money, but human beings' time, health, mental well-being, that's really all we have. And independently of any kind of monetary circumstance, there is a strong difference between being imprisoned and confined in those circumstances and being anyone in civil society. There is a huge difference.
Day, Fakiri's brother, Yusuf, told CBC News. But what this report does effectively is what should have been done 5 years ago. Their one hope now is for criminal charges against the guards involved in Fakiri's death and for his case to serve as an example so that no family has to lose a loved one with mental illness this way again.
And it's important to reflect upon the process by which investigations are conducted. If you file a complaint with the Office of the Police Complaints Commissioner, with the Human Rights Tribunal, with the BCCLA, or with any appropriate lawyer, I don't think there is the necessary amount of driving, motivating force for such organizations and the individuals that constitute those organizations to be able to effectively address these issues. I see it as being the predisposition of the power structure to reinforce their own power at the expense of many of what would be the upholding of instances of the upholding of human rights, or just the honoring of a greater sense of humanity. That is not to say that the Canadian justice system is without its triumphs. I think so many of the people in this nation do appreciate the successes of our culture, of our society, our government, and our justice system. Those are not to be denied. But it is this margin of error, it is the margin of deficiency that is the problem. And if we can continue to make incremental improvements in that margin, then that's what we should be doing. And I would just like to suggest that as an individual placed in the circumstances that I have been by fate, and developing a personal connection to these issues, I feel as though if the justice system, I can only speak from my individual perspective, my individual circumstance, but I feel as though my personal establishing of justice through my own case and everything that applies to it, all of the legal precedent and all of the technical matters of legal precedent and evidence and the investigation of the facts and cross-referencing with pre-established precedent. All of those factors are the only thing that I can immediately address in any real way in order to try to set my own particular circumstance straight. And I would ask any individual who may be considering this to think about the ramifications of me being able to establish and orientate myself toward assistance in such respect. So if I can't help myself, if I am entirely rendered without any ability to address my own immediate legal concerns, then I'm never going to be in the position to lend assistance or attention to other people, because if I'm not able to feed myself, why would I be feeding others? Or if I'm not able to establish a decent form of justice for myself, then I'm disempowered and I'm at a loss.
Again. As a result of the chief pathologist's report, the case has been referred back to the Ontario Provincial Police, meaning criminal charges could possibly be back on the table, the family's lawyers say. 2 previous criminal investigations, by the Kawartha Lakes Police Service and the OPP, respectively, resulted in no charges being laid against any of the guards involved.
It's a difficult thing to consider being a prison guard. I know it's not an easy job. I visited one of the correctional facilities, a youth correctional facility in Burnaby, when I started to think about these issues. And it's the individuals working there and the specialists working in relationship to the people held in detention is a very, very abstracted mindset and perspective on the prisoners. Like, from my perspective, I had a whole very far removed idea of what can be done in interacting with them, and the professionals working at the facility, I never expected them to say some of the things that they did or to tell me about some of the policy as it exists.
Involved. Fakiri's family has been asking for years what killed their beloved Soli, only to be told there was no way to know how the 30-year-old had died behind bars. Richard H. Coute, CBC. There is no mystery remaining. We now know that Soliman Fakiri was killed with a lethal combination of excessive force, said Edward Marocco, one of the lawyers representing the family. There is no justification for what was done to him. There is no training that authorizes correctional officers to use this kind of violence. Polonen has drawn a direct connection between the brutality Soliman endured from the guards and the death of his body. There is no mystery remaining in the killing of Soliman Fakiri. Fakiri, or Soli, as his family knew him, had been a straight-A student and captain of his high school football team. But his life took a turn when he was diagnosed with schizophrenia at 18 after a car accident. Over the years, he was repeatedly taken into custody under the province's Mental Health Act, but had no criminal record. At the end of the day, is there relief? Yes and no. Soli is gone, he's not coming back, and a part of my...
So perhaps we'll return to this. I just wanted to mention that because this is the posting of the BCCLA. Moreover, I think just addressing this platform and this format of publication and communication is important to do, because I think in many ways it's a complete optimization, providing the public with transparency, the ability to comment and interact with each case in a direct way. And we could take administrative steps in order to fully legitimize such aspects where the weight that the courts would place upon such interaction with the public, such interaction with litigants in this technological context would be held at higher regard. So it's very informal. I've posted to in response to the Supreme Court of Canada numerous times. So for instance, this last post. So like, I do joking things. So like, I'll take that off. I've posted a significant response here. I've never received any direct response. And what I'm suggesting is that if I was in the court's position, depending on the discretionary judgment call of any adjudicating party with regard to such communications, I think there are administrative steps that could be taken in a direct, immediate way in order to expedite many of the processes that would apply to the optimization of the processing of these cases and legal concerns. So, for instance, if I am in the circumstance that I'm in, I don't think that it should be entirely unreasonable to try to engage the person that is putting forward communications to the judiciary in a direct way so as to reach a better understanding of the facts. It's a matter of drive and policy, formal policy, or the just general tendency of the courts to basically surrender whatever advantages could be gained in such an administrative way of approaching this circumstance. For instance, the judiciary could respond to each one of these on a discretionary basis, based upon the prima facie validity or invalidity of such content. So if I'm fairly certain that this is real, and the judiciary is in the position where they could at least address our communications to them as efficiently as possible and directly, I think that could bring about some positive things. It could usher along the unfoldment of the law in a beneficial and more optimal way. So if I were in the judge's seat, I would say to somebody like me, I would post a comment saying, here's a link to schedule chambers with a justice regarding what you've posted here. Here's a direct link to take the proper administrative step. Because if I go to the registry and I begin to talk to the registrar, they'll give me information such as file an application to the court, file a notice of application. And when I go onto the website, the notice of application, once completed, is not accepted by the registry and rejected. And it's very difficult when standing in front of the registry, in front of the registrar, and attempting to submit documentation or forms to come to any kind of real fair understanding with them. I mean, they're a registrar, but they're able to essentially exact the authority of the judge with regard to applications. Like if I'm filling an application to the court to request that a justice directly assess my previous applications for their validity or the formats of submission that I'm attempting to make with the court, then that needs to be assessed. That needs to be adjudicated. And the registrar standing at the desk with the public immediately in front of them has very little ability to consider all of the factors that are brought to them because it's such an immediate and direct way of interacting. So I'm going to, I just wanted to address that because I think in general, the offerings put forward by the Canadian justice system in terms of the Supreme Court of Canada's Facebook page, their Twitter page, the British Columbia Court of Appeals Twitter page, the BCCLA's Twitter page. So I've attempted to establish some kind of viable two-way communications with all of these organizations, and they are a complete and utter stonewall in terms of establishing two-way communication. So there, according to BCSC Criminal Rules, Rule 1, Article 9, any rule of the court can be dispensed with at any time. So hypothetically, if I were to appeal to the BC Supreme Court via the Twitter page, at the discretion of any presiding judge or justice, I could be granted an acquittal just as anyone else could be. And I'm just talking about that raw, direct efficiency in implementing the platforms, the technical realities of the technology toward the full optimization. And that's not to be dismissed as trivial. If we were able to achieve that full efficiency and optimization, first, just going for what is technically possible and pursuing the absolute limits of technical possibility rather than legislation that was drafted decades ago and we're dealing with a completely different technological circumstance today, or just a general bureaucratic and capitalist injustice, whether we're dealing with one of or both of those factors that could hinder the progress of justice in our society, is the question, or whether we can overcome that predisposition toward this state of things as they currently exist. So I'm going to review both of my particular case files just in full. But first, I'm going to review more in depth, as I said I would in the previous upload that I have offered the public, review the specific judge's reasons as recorded in this hard copy of 64950-1 on behalf of Judge Bryce Dyer. So I'm going to review Judge Bryce Dyer's reasons, some of the audio transcripts from my trial. Then I'm going to review my appeal and my Can Lee appeal and discuss it as I go through. But I think I'm going to cut this video. So if you're interested in those aspects specifically, please, by all means, join me in the next upload that I will offer via these channels. Thank you so much for your time.